rise, if we will there. Please be seated. We will as well.
Thank you very much. The next witness for the prosecution would be witness 516, appearing as a result of the summons issued to him. And in Nairobi, we understand that there is counsel assigned to the witness. Is that the case?
Yes, Mr. President, the counsel of witness 516 is present in the transmission room.
Thank you. Sir, could you kindly state your name for the record?
Mr. President, my name is Wandugi Karathe. Could I spell it?
You spelled it the last time, wasn't that the case?
Yes, Mr. President.
Yes, we have it on the record, Mr. Karathe. We have been informed that you have been provisionally admitted to the list of counsel entitled to represent persons before the court. Is that the case?
Yes, it is, Mr. President.
Is it
And I'm grateful.
Noted. We also understand, is that the case, that you have been given access to the statement or statements of witness 516? Is that the case?
I have been given access. I have been able to go through it.
Thank you. And have you had an opportunity to review the statements with the witness 516?
I have had some time since Friday, Mr. President, but I fear I didn't feel time was sufficient. But I understand the timelines.
You feel what?
I feel maybe I could have gotten a little bit more time, but I do appreciate the court's timelines.
All right. So
Granted, which I'll do my best.
So you could have needed more time, but you were able
Yes.
to do what you could.
That is so, Mr. President.
Thank you. We note that your role is limited solely to the question of the possibility of self-incrimination by the witness and to advise the witness in respect of the applicable provisions of the court's basic documents that deal with that question, and also in assisting with intervention that may be needed to be made in that regard in the course of the testimony. Have you had occasion to review those provisions, specifically Rule 74 of the Rules of Procedure and Evidence of the Court, as well as Articles 70 and 71 of the Rome Statute?
Yes, Mr. President, I have had a time and a chance.
You have had the time and the chance to review them.
That's so.
Yes, the chamber will require you, or we do require you to specifically advise the witness of those provisions. Have you done that so far?
Yes, I have, Mr. President.
Now, it is not the role of duty counsel appointed in these circumstances. It is not your role to direct or guide the testimony of the witness as to the merits of the case. The limitation, your mandate is simply what I've indicated, where the possibility of self-incrimination rises, to advise a witness to, as you said you've done, on the provisions of the rules as well as the Rome Statute, and also to be on standby in case that sort of possibility rises in the course of the testimony for you to intervene at that stage and help the witness make any observations or submissions, legal submissions that may need to be made at the appropriate time. Also very, very critical in this in that task is to be on standby to signal to the court when an answer to a specific question might engage that possibility, so that we can go into private session to receive that answer. Ordinarily, it is or generally speaking, it is the task of the lawyer who's asking the question to signal that possibility, to tell us, well, we are now going in the direction or the territory of the possibility of self-incrimination, so that we will take the appropriate measures. So the prosecution will be on the lookout for that and will tell us when that possibility arises, as well as the defense counsel. But you're also there to assist in case there's been an omission to do so on the part of the questioners. Do you understand?
I do understand that, Mr. President.
All right.
And I'll be ready.
Thank you. Now, the prosecutor will have to advise us on possibilities of self-incrimination, and we will go into private session to receive any submissions the prosecutor may have. We'll go to private session now.
We're in open session, Mr. President.
Thank you. We will render 2 rulings on the matters discussed by counsel. First ruling on Rule 74, and secondly, we will render a ruling on the in-court protective measures. After the ruling, we will adjourn and start back and return at 2:30 for the witness's testimony to commence in earnest, and that will give Mr. Karate time not only to advise the witness of the chamber's ruling, and also the little more time he'd indicated he could have used. First, the ruling on Rule 74. The chamber notes that an issue of self-incrimination may arise in the context of the anticipated testimony of witness 516. The chamber has had the submissions and the undertakings by the prosecutor, and also we've had the views, to the extent that they expressed any views, put on the record by counsel for the defense. Where issues of self-incrimination arise, the chamber may, having consulted in particular with the prosecution, provide an assurance under Rule 74 of the Rules of Procedure and Evidence, in order to enable a witness to testify truthfully without fear of the consequences of self-incrimination. As has been done in the past, this assurance is granted with respect to witness 516 under the same conditions as with previous witnesses. That is to say, in relation to Article 70, Sub 1, Clauses A and B, offences covered are offences committed in the phase of the court, in the course of testimony. Perjury, or giving evidence knowing the evidence to be false or forged. The chamber does not absolve witnesses who come before it in relation to those specific offences, but where a witness comes to court and testifies truthfully or does not present false or forged evidence, that witness need not fear incurring liability under those two provisions. In relation to Article 70, Sub 1, Clause C, information provided by the witness during his testimony before this chamber may not be used in any subsequent prosecution against him or her, directly or indirectly, in relation to the offence indicated in Article 70, Sub 1, Sub C. For any part of the testimony of this witness where issues of self-incrimination arise, the following measures will apply. The evidence shall be in private session or in closed session. The identity of the witness and the content of such confidential testimony shall not be disclosed in any manner. Counsel for the accused, as well as their clients, parties and participants, and court staff present, or persons who otherwise have access to the evidence or the testimony, are hereby specifically cautioned that breach of this order may result in sanctions under Article 71 of the Rome Statute. The relevant confidential transcripts of the evidence of this witness will be placed under seal, and the court will apply appropriate protective measures to any subsequent decisions in order to give effect to this order. As indicated when I was directing remarks to Mr. Karathe, it will be primarily the responsibility of the parties to ensure that all questioning which may touch on aspects of the witness's evidence likely to give rise to issues of self-incrimination is conducted in private or closed session. The witness or counsel on the witness's behalf may, in the same manner, also request private or closed session if it is anticipated that an answer to any particular question may give rise to self-incriminatory testimony. Counsel is directed to ensure that the witness is fully informed of and understands this ruling prior to the commencement of his testimony, the witness's testimony. Restrictions and contacts with witnesses during that testimony will apply in respect of witness 516. In particular, for the duration of his testimony, counsel assigned to him is only permitted contact with the witness on the conditions applicable to the legal representatives of dual status witnesses. Accordingly, counsel should refrain from holding any substantive discussions with the witness about the topics that are to be dealt with during his testimony or evidence that may be produced. But again, as indicated all along, the counsel for the witness has been retained for the specific purpose of advising the witness as regards Rule 74 or the possibility of self-incrimination and what may be done. For that reason, he may at any time confer with the witness to give him appropriate legal advice in that regard. It is also the ruling of the chamber that the basic principles of contact with witnesses as set out in the witness's preparation protocol shall apply in respect of any contact whether before or during the testimony of witness 516, including any contact with counsel. These principles prohibit coaching, training or practicing of testimony, as well as any attempt to influence a witness to testify to factual events the witness did not observe or perceive. This concludes the ruling of this chamber at this time. On the second ruling on protective measures for the witness in the courtroom, the chamber notes that the prosecution had on the 28th of August 2014 filed the request for the usual suite of protective measures, specifically image and voice distortion, the use of pseudonyms, testimonies in private session when necessary, and redactions to public records where necessary to prevent identification of the witness. On the 5th of September 2014, the VWU provided its observations supporting the prosecutor's request, and noting in particular the circumstances in which this particular testimony is being taken. In particular, the witness is not here with us in the courtroom. I also note that the prosecution had indicated in their own submissions that the circumstances of the possibility of self-incrimination is also a matter to be taken into account in the chamber's decision on protective measures during the testimony of the witness. The chamber has heard the observations of parties and participants in the case, and the chamber grants the request made by the prosecution. That concludes our ruling on that matter. We will adjourn now and come back at 2:30 for the testimony of the witness to start in substance, and during which time, during the intervening period, Mr. Kirate would have had more time to discuss with the witness or advise the witness, and specifically inform the witness of the chamber's ruling.
There's one matter I can briefly raise, perhaps. It needn't detain the witness, nor Mr. Karathi. And in fact, it would be better said, perhaps, with the connection severed, as it were.
We'll go to private session.
We're in open session, Mr. President.
As the Chamber will know, we receive copies of material in various degrees of redaction, and sometimes the same material in progressive degrees of unredaction. The position here is that we received the statement of this witness, 516. That's the statement that's KenyaMOJA.com 0087-0031. And the last version of that, which I was aware and working with, was RO5, version 5. Normally they go up to 2 or 3, but this one had achieved 5 as a point of further redaction. And we asked for the unredacted statement, not least of all because there were 2 redactions, or at least 2 redactions, in the version R05. And those redactions related to paragraph, I think it's 34. Let me just check on that. 36, rather. And also, and rather surprisingly, to paragraph 124, a token of which I can show you that from the bundle that was compiled for me from the documents that the prosecution were going to list in evidence, that particular page appears like that. You can see that the entire paragraph is blacked out.
So, 1 second, Mr. Hooper, something just occurred to me. Ms. Dumai, you can...
Yes, Mr. President.
You can, just in case, I remember when I told Mr. Karato to step out, I said for a moment, he might be standing out there or sitting out waiting to come back in. No, he can move on now and do what he needs to do with his with the witness. We'll see him at 2:30.
Okay, sir, I'll tell him.
So coming to paragraph 134 from your site on the bench, you can see from what you saw when I displayed the page that that particular paragraph was still redacted. So we asked for, with this witness now imminent, for the prosecution to consider lifting that redaction or else place it again before the Chamber. And we then last week received R06. I'm occupied with another witness. Over this weekend, placed my attention, of course, on the upcoming witness. I'm very surprised when I see the contents of 124, which, as far as the accused that we represent is concerned, is the high point of this witness's testimony. And so I'm asking the prosecution, through Your Honour, to explain why it was that this was redacted until just a few days ago, and what the explanation is for that, given their duties of disclosure and preeminently their duties of disclosure when it comes to incriminating material, because we, the defence, have not had an opportunity to investigate the allegation that's contained there. And what's particularly perhaps striking about it in the little that I've been able to uncover in any event is that witness 613 in her testimony, you may recall, was asked something about this subject, and as I understand it, clearly contradicts in her testimony, her evidence that she gave, the account that's contained in 124. I was deeply shocked and surprised when I saw the contents of that paragraph revealed. And it's also, the name was the redacted name. The name that appears in that paragraph is, again, the redacted name that appears in the much lesser redacted paragraph that appears at paragraph 36 that I referred to. Yes.
Hold on, Mr. I ordinarily, speaking for myself, I try to avoid looking at witnesses' statements before they start testifying, because I want to have in my memory what the witness says in court. So, but now that you drawn our attention to paragraph 124, we don't even we have it redacted in the version we have, so we don't have paragraph 124.
Well, I was deeply surprised and shocked, and I don't like using hyperbole. Those were the, I think, two adjectives that I think would describe my reaction when I read that paragraph. Now, it might be that the prosecution have chosen not to rely on that paragraph. But if they haven't, then I'd ask the court to make it mandatory that they do ignore the contents of that paragraph. Because service on the defence of incriminating evidence of that kind cannot be done at the relatively last moment. I don't know what the explanation is, and I dare say the prosecution may be able to present you with one. But I cannot see for the life of me what could possibly justify the position that the defence have now been placed in. And Your Honour, I'll say no more at the moment.
I think you've made that point very clear.
Yes, thank you.
Thank you, Your Honours. The redactions in question deal specifically, and I bear in mind we're in public session, but with a particular former witness of the prosecutions, whom the prosecution decided not to call as a witness as a result of serious security concerns relating to that witness. And as much as we would have liked to have presented that witness to the court and evidence relating to that witness, the prosecution took a conscious decision not to rely on the evidence of that witness. The same goes for the paragraph which has been redacted. However, Your Honours are aware that as a result of it...
Are you saying then that you will not be relying on paragraph 124?
We will not be relying on paragraph 124 or any other matters relating to that former witness that are referred to in this statement.
Does that satisfy you?
Yes, it does.
Okay, maybe we should not prolong the debate then.
Yes.
Yes.
And
we'll leave it at that.
I can calm myself.
Yes. So hope you recover from the shock. Hopefully.
And Your Honours, I would have been happy to have advised the defence had they asked me of that.
That's why it's always important to exchange views amongst counsel, and where matters are not resolved, then we can take them up before the chamber court would adjourn, and we come back at 2:30.
All rise.